so we'll go ahead and get this started. My name is Blake Bingham. I'm the Assistant State Engineer for the Division of Water Rights, responsible for water rights adjudications. Some other notable figures in the crowd, we have Mark Stilson. He's the Regional Engineer, so he's kind of the director of all this entire region. He handles the appropriation process, and it's also his staff that will be doing a lot of the boots on the ground type of work, evaluating claims, receiving claims, and that type of stuff. And I saw Ben Jensen. He's back in the rear. He's an assistant attorney general. He represents the state engineer's office during the general adjudication. So if you have an attorney, or you are an attorney, you want to talk to an attorney, he's your man. But we'll go ahead and get this underway. Here's the overview of what we're going to talk about tonight. We're going to talk about what a general adjudication is. We'll kind of dive into what a proposed determination, that's a key word that you'll hear over and over again tonight. We'll talk about some of the significant issues, and then the questions are really throughout. If you have a question that has to do with a principle being discussed, you know, and there may be some application to other members in the audience, please raise your hand and ask the question. Don't feel bashful. If it's a question that really only has to do with your specific scenario, your situation, I might ask you just kind of hold off, and I'll stay here till 9 o'clock at night answering questions if you have a specific question that is unique to your situation. But otherwise, ask the question, and if it is maybe specific, I might just defer it for later. For those of you who are viewing online, that email address at the bottom, as well as those in the audience, is an email address you can reach any. This actually goes to my email, but if you have any water rights or adjudication related questions, you can ask that online. If you have a question throughout the presentation, send an email to that email address there in blue at the bottom. At the conclusion of the presentation, I'll check by email and attempt to answer those questions for the online listeners, as well as for the others who are gathered here tonight, just for everyone's benefit. So those are the rules of engagement. If you got a question, ask it. If you're unsure, ask it, and I'll tell you whether it needs to be held on for later or not. Let's start off with, water rights aren't a well-known concept, and so I often find that part of my presentation includes just kind of getting people up to speed on what is a water right, because I think sometimes you receive this scary piece of mail, this summons saying you're going to represent yourself in court and you're not sure what's going on, and often the first response is to call up our office and ask, well, what's going on, and we'll talk about water rights, and the next question is, well, how do I know if I have a water right? So I'm going to explain what represents a water right. Also, I forgot to add, the piece of mail that you received, the summons and notice of this meeting, you are in no way required to stay here. Your attendance is not required. I know the summons can be confusing. I apologize. That's just part of the general adjudication statute. It is a court proceeding, and so that summons is necessary. If at any time during the presentation you feel like your curiosity has been satisfied, go ahead and stand up and head on out. No need to stay to the end of the presentation. But let's get back to what is a water right. Well, typically, a water right is defined by some of these attributes. First of all, you have a defined nature of beneficial use, and that's kind of fancy words for just saying, what is it used for? Is it used for irrigation? Is it used for stock watering? Is it used for your culinary purposes inside your home? And in Utah, beneficial use is the basis, measure, and limit of the water right. So when we talk about a water right, we're really talking about what is it used for, not how much water, although those are certain characteristics, but really what is the water being used for? How many stock water? How many acres of irrigation? Your water right will have a priority date, meaning that's where you are in the line of getting your water. Utah is a prior appropriation state, meaning first in time and first in right. So if you had your great-great-grandfather appropriate water back in the day from Mill Creek or something to that effect, you have a pretty senior water right. You get your water before subsequent settlers, and we'll talk a little bit more about that later. There's a defined quantity of water allowed for diversion. When we say diversion, that's another fancy word for simply saying, hey, we're taking the water out of this natural source and we're moving it over here. So that could be by flow rate, such as cubic feet per second, or we have an acronym, CFS, or by volume, which is an acre-foot volumetric measurement, so an annual acre-foot volume. If you can imagine a yard that's 1 acre in area and water 1 foot deep, that's an acre foot. It's pretty self-explanatory. A specified point of diversion, which again is where the water is removed from the natural source. So if it's a well, that's the well. If you're taking water out of the groundwater. If it's a spring, it's where your spring box is located. If it's a ditch off of a stream, it's where the head gate of that ditch is located. That's what we call points of diversion. And then a place of beneficial use is just what it sounds like. It's where you're putting your water to beneficial use. We typically measure that or locate that based on the public land survey system. So what 40-acre tract within what section, within which township and range. Sometimes you might see evidences of water rights in your property if you have a well. There's some wells pictured there on the right and the left. Those are kind of small domestic wells. Or you might have some irrigation ditches, some head gates, is what's shown there in the center. Now, what's the difference between a water right and a share? And this is kind of one of a point of confusion among a lot of people, especially if you're a shareholder in an irrigation company or a water company. Your share as a shareholder is different than the water right, okay? Your share represents your share of interest in the company at large, and the company is the one that owns the water right, okay? So they essentially own the water right, and then they distribute water to their shareholders based on their representative shares. So you may be a shareholder, but you may not be a water right owner, or at least a direct water right owner. The company is the owner of the water right. It's also not a connection to a public water supplier most often. I know in Castle Valley, they have a bunch of individual wells that are owned by the town of Castle Valley. And so in that case, that's the one exception. But usually I'm talking to people up in Salt Lake City who are wondering whether the water coming in from the meter is a water right. And that's not the case. So if you're served by a public water supplier where a line's coming off the lateral, going to your water meter and going to your house, that's not the same thing as a water right. Okay. So just to kind of give everyone an idea of why we do general adjudications, how that's different than the appropriations process, I have to kind of take a couple steps back and talk about the historical context of Utah water law, because it plays a big role in why we're here now, and what are we doing. So you'll forgive me, I'm going to do a quick history lesson. I promise I'll try to make it as entertaining as I can. If you've been to these presentations before, this is the same jokes. Don't feel obligated to laugh at them. All right. A lot of us know the story. July 23rd, 1847, an advance party of Mormon pioneers entered the Salt Lake Valley and started diverting the waters of City Creek to kind of soften up the soil so they could get a late crop in. This is a lot funnier up in the Salt Lake Valley. They actually have a mall where that is now, so it's the City Creek Mall. Anyways. Later on in the year, Brigham Young made this statement. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." And really, that's a basic tenet of water rights, in that the water is it's a public resource. It's owned by the residents and citizens of Utah. The state of Utah's role, or when I say the government of Utah's role, is really to ensure the equitable distribution and to ensure that people who have water rights receive their water. And so that's really our role. The state doesn't own the water, the government doesn't own the water. We all collectively own the water as a public body. It's just administered by the state. I'm not sure if that makes anyone feel any better, but I have to put it in there anyways. Well, between 1847 and 1850, what we now know as Utah went from being part of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. However, as most of us know, because there was no real organized government, the government was really centered around the Church of Jesus Christ of Latter-day Saints. And I'm just going to abbreviate the church from here on out, okay? They remained church-centric. They filled that power vacuum. As a result of that, diversions of water from the streams were generally on a communal basis. They're done just to meet the immediate needs of the settlers who occupied these valleys in different parts of Utah and Nevada and Arizona. The doctrine of priority kind of evolved from the leaders' recognition that you would have the first settlers would come into a valley, put a lot of effort and work into digging these ditches, and diverting the waters from the streams onto their crops. But then they would always, and they recognized that, hey, they put a lot of effort into that, so they give them a primary right. But they also recognized that there would be follow-on settlers, and those settlers didn't put as much work into the ditches and whatnot, and so they got what was kind of a secondary right. So the primary right were to those who were first there and did all the work, and then the secondary right were to follow-on settlers. That combined with kind of this concept of priority in gold mining, or in the mining scenario, kind of evolved and shaped into what Utah now has as far as a priority system, where you're first in time, you're first in right. And that's kind of the law of the West, both in water and in mining. Conflicts were often settled through ecclesiastical channels. It had bishops' courts for local ward members. If there was a conflict between two members, someone was stealing the other person's water, they'd go complain to the bishop. The bishop would kind of, say, okay, well, I think you need to take your turn here and your turn here. And if they didn't like what the bishop had to say, they'd take it to the stake high council as kind of the appellate court and say, oh, Bishop Jones, I'm afraid you erred. This is really how we're going to divide this up, okay? Well, as you can imagine, that didn't really fit the template that the founding fathers had established, this concept of separation between church and state. So once Utah became a territory in 1852, the first territorial legislative assembly passed an act that gave the authority to the county courts to administer both timber and water rights, okay? However, really, it was only Salt Lake County that followed this. They were the most populous county, probably the most, for lack of a better word, Gentiles in the sense of non-Mormons being Gentiles, that really followed this, okay? And another thing that was kind of funny about this is that the county court, to be a judge on a county court, you were elected to that position. So you can imagine who were the people being elected to these positions. It was the bishops and the stake presidents. So in fact, there was really not a whole lot of change or difference between what was going on previously and to what happened under this law. Well, in 1877, the Desert Land Act was passed by the United States Congress, and that was really to promote the homesteading of the arid West. It had a couple of consequences. First of all, it severed title from the land and the water. And if you think about it, back east, water is plentiful. And as a matter of fact, they have this what's called the riparian doctrine, where if you live next to a river or a stream, you automatically have a right to use that water, okay? But they didn't really divert it and use it in the sense that we do here because they had adequate rainfall and precipitation. Well, the Desert Land Act recognized, hey, we've got to homestead this arid wasteland, and the only way to do that is to divert water from a stream over here and carry it to a 40-acre tract or 120-acre tract over here and irrigate it. And so that was kind of one of those unintended consequences that says, all right, you don't have to live right next to the stream in order to own a water right. As a matter of fact, they are different types of property rights altogether. Another consequence of that also delegated authority to the individual states or territories to manage how water rights were appropriated, established, and managed there forward, okay? And to us, that might seem kind of like an obvious conclusion. But if you can imagine that the government land office, is in the United States government land office, was still issuing patents for land. So you could have imagined, well, they should issue patents for water. Well, this essentially said, nope, the states are responsible for that. And what you had in all the different western states is different ways of administering water rights throughout the West, okay? And we'll kind of see where Utah fell on that spectrum. Well, because the 1852 Act was such an abysmal failure, they tried to take a different tack. They passed a law that called for the appointment of county selectmen who would go around and kind of look at these diversions and issue little certificates that they could then record at the courthouse or at the county recorder. Again, that was largely ignored, and it was even kind of found a little bit unconstitutional or sideways with common law, because generally courts are responsible for adjudicating property rights, and this was kind of an executive branch doing that under this system. So it fell apart. It really never worked anyways. As a result, confusion continued in spite of the best efforts of the territorial legislature or the church. And the church continued to administer and decree water rights. This is highlighted by an 1879 High Council decision. So if those of you not familiar with the ecclesiastical system of the Church of Jesus Christ of Latter-day Saints, High Council is a board of ranking officials within the church. They made a determination that the Spanish Fork River should be divided among these different canal companies, and that's the way it's been ever since. There's been subsequent decrees that kind of tweaked it here and there, but if you look at it still today, it's still those same canal companies dividing the river of the Spanish Fork in the way the High Council originally decreed it back in 1879. So, 1896, Utah gained statehood. There was a lot of concerns about, as you can imagine, okay, they're becoming a new state. There's a new opportunity to create new laws. Part of that system of laws that they're looking at is, all right, what do we do with the administration of water? And so there were some who thought, well, what we should do is we should just say, hey, if you've been using water, you no longer have a right to do that. The state is going to confiscate everything, and we are going to own it, and then we will piecemeal it back out to you. And obviously that raised huge alarms among most of the people because everyone was based, agrarian based. They relied on this water. And so there was a big fight, an internal struggle, and so they decided, okay, this is getting way too controversial. We are simply going to punt, and all we're going to say is, hey, if you have been using water, you are good to go from here on out. And so it's even captured in this Utah State Constitution under Article 17. It says, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So if you had been using water up to that point, you had a right to continue to use water. And what they decided is we'll figure out the rest later, but we're just going to make sure people who have water now are safeguarded in the future. And so we often call those grandfathered rights. The common parlance today is diligence claims or pre-statutory claims, and we'll talk a little bit more about those later. In 1897, the Office of the State Engineer, what we now know as the Division of Water Rights, was established. But his office was really tasked to simply draw hydrographic survey maps. Go and map Utah and find out where all these streams are, identify the capacity, look for good places to build dams, those types of things. Appropriating water rights was still done in the same old-fashioned way where you go hammer in your claim and then go file that claim at the post office or the county recorder. And again, that was largely ignored. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, was established. And as their name implies, they were tasked with reclaiming the West, right? And they would do this by going and finding big areas to dam rivers and create big reservoirs so that they could then capture that water and promote agriculture. It would give farmers a reliable source of water to irrigate large tracts of land. But they were really reluctant to do that in any state or territory that didn't have a system for identifying the existing rights or appropriating new rights. So they pretty much said, hey, we got this great program. It's pretty much free water. They didn't sell it like that, but that's pretty much what it turned out to be. But if you want to play ball, you have to have some type of law of appropriating water rights in place. And Utah didn't have anything at the time. So no coincidence, 1 year later, 1903, Utah enacted its first water law, which provided for appropriating surface rights. So prior to 1903, in essence, all you had to do was go stake your claim in and divert water, and you were good to go. After 1903, you needed to appropriate a water right through the state engineer's office. The law also allowed for adjudicating rights, and so that's the term we're kind of keying on, right? Adjudication. The idea of the adjudication was to go and find all these existing rights that had already been put to use, all these diligence claims, these grandfathered rights, because obviously people had been diverting water since 1847, in some cases a little bit earlier, depending on where they were at, throughout the state of Utah, right? And it is imperative that we know how much water has already been appropriated through these pre-existing rights. And so it was kind of a two-pronged attack, right? We're going to find out all the existing rights, and then we're going to appropriate any new rights. And that's how we're going to manage, that's how we're going to know how much water has been called for. Unfortunately, the legislature prevailed to provide any funding to the state engineer office to actually do this. And it really didn't work because in a court system, you really need adversaries, right? You need a plaintiff and a defendant. Simply having the state engineer simply saying, all right, court, go out and figure out the water rights. Courts really don't know how to do that. Judges don't know how to do it. They know how to decide between conclusions of law and facts between competing parties, but to simply say, go figure out the water rights, the courts weren't really equipped to do that. Well, in 1919, they finally figured out the courts aren't really going to do anything, so they came up with a new idea, and the idea was, well, what we'll do is we'll task the state engineer to go out, do hydrographic surveys, take claims, and then issue a recommendation to the court. So the state engineer is one of the parties, and he'll bring the recommendation to the court, and then the court can make a ruling on that. And people who don't like that ruling can come in adversarially and object to that. Okay, and that's kind of pretty much the same concept we use today, where we do a proposed determination, and I'll kind of get in more depth, more detail on that here in a bit. And then in 1935, they said, hey, this is a really great idea for surface waters, but this groundwater is kind of connected to surface water. We should probably have some laws on it too. So prior to 1935, you could go punch a well in anywhere you wanted without a water right. After 1935, they said, hey, well, groundwater and surface water, it's really connected. There's no doubt that streams can be gaining and losing, and that's associated with the water table. And so they passed a law saying, all right, from here on out, in order to get a well or to drill a well to appropriate groundwater, you got to do that through the state engineer's office, similarly as you had to have done for surface rights after 1903. So 1903, 1935, those are your two key dates. Okay, so prior to the enactment of this comprehensive water law, the rights to the use of water kind of fell into a couple different categories, maybe 5 different ones. You had those that were decreed by ecclesiastical leaders saying, yep, you get the water this day and you get the water this day, or we're going to split the Spanish Fork River this way or the other. You had those claims that were filed for record at the county. These are really hard to find. We found a bunch in Salt Lake County. It's been hit and miss elsewhere. You had those rights that are decreed by a court. Again, that's from parties coming to say, hey, this guy's still in my water. So they go and sue each other, and then the judge decides, all right, I'm going to give you the water on this day and you the water on this day. Again, they didn't really have a whole lot of formal education. They often appropriated more water than was in the actual stream, but they were just trying to do the best they could based on their understanding of law. You had unilateral contracts or agreements between parties. You have a lot of those up in Salt Lake Valley, where Salt Lake simply said, hey, I know that you use this clean canyon water, and we got this awesome Jordan River water that smells like duck crap. Tell you what, let's put this duck crap water on your grass, and then we'll use that water for culinary purposes. And that's kind of how they made those contracts, and they just kind of did it between each other. There was no other record of it. Then you had those claims that never manifested themselves on the record anywhere, okay? So these are the people who had these pre-statutory rights. They weren't required to come forward. They are grandfathered in. They had no reason to come forward or do anything, so they continued to irrigating. So they were kind of unknown, and they continue to be unknown in some instances. As a result, there's no kind of definitive water law, there's a couple issues. First of all, there's no public record. There certainly wasn't a consolidated or comprehensive public record to be found. Because there was no record, over-appropriation was rampant, and rights weren't defined until they came in controversy, and they were either settled by the church or by a court. The state engineer recognized this issue back in 1902. Remember, state engineer's office was created in 1897, so 4 years into, he's like, hey, this is crazy. We've got to figure something out. And he said, the definition of existing rights, meaning those are the rights that were happening prior to 1903, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record. So the idea is, hey, what we're going to do before we start appropriating any new rights, we're going to go and adjudicate all the existing rights. Then we'll know where we're at, and then we can appropriate new rights moving forward. Well, as I've already said, that system kind of failed, right? The legislature didn't provide the funding, the courts didn't really know what to do, and people were tired of waiting for this process to catch up, so the state engineer said, all right, forget it. Let's just start appropriating new water rights. We'll do the adjudication in tandem with the appropriations process. And so they started doing that in certain areas. It's kind of hard to see probably from the back here, but the Weber River, the Sevier River, the Virgin River, those were all adjudications that were initiated back in the 20s. You know, remember that the mechanism of the proposed determination was established in 1919. So they started getting busy with it, right, to adjudicate those basins. All these other basins are also under adjudication orders, either active or ones that were initiated long ago. So what is an adjudication? As the name implies, it's an action in state district court. It's a legal action, legal proceeding. It binds all the water users, including the state engineer. We're all governed by it. And it's governed by Title 73, Chapter 4. If you really want a confusing piece of literature to read at nighttime to put you to sleep, there you go. That's my recommendation. The first general adjudications took place in the 20s, the Sevier, Weber, and Virgin River basins. But as you can see, other ones were also initiated. Now, you probably can't see the dates, but a lot of these dates happened in the 1950s. For the general adjudication that we're talking about tonight, so we talk about the Moab South Subdivision, but it's really the Moab South Subdivision of the Southeastern Colorado River general adjudication. So that whole southeastern part of the state is the general adjudication. And it was kicked off back in 1957. And you're probably wondering, why are you finally here? What has prompted you to get here now? What's taken so long? We can talk a little bit about that. But it's more interesting as to why it happened in 1957. I'm going to talk about that here shortly. First of all, why do we conduct general adjudications? We want to get all these pre-statutory rights, all these grandfathered rights. We want to bring them onto the record. And the adjudication requires people to bring those claims onto the record, or else they forfeit their claims. So this is the opportunity for them to do that. So this kind of is the carrot or the stick, whichever way you want to look at it, to force people to come onto the record if they have one of these types of claims. And again, for surface water rights, that's prior to 1903. For underground water rights, that's prior to 1935. Federal Reserve rights. Okay, this is really when I'm saying how things started in the 50s, why we started doing a lot of these adjudications. Well, this is the real reason why. Back in the turn of the century, the Fort Belknap Indian Reservation, obviously the Indians had been forced onto this reservation. They were told to become civilized, and part of that was you need to become agrarian, you need to start cultivating crops, which maybe that wasn't what they were doing. They were kind of more nomadic. But they said, okay, fine, we're stuck on this reservation. You want us to be agrarian. That means we need a source of water in order to irrigate these fields, and this is up in Montana. And so they went to the equivalent of the state engineer in Montana and said, hey, we're on this reservation. We need some water from the Milk River to irrigate. And the state engineer said, tough luck, Chuck. All the white settlers have already appropriated all of the water of the Milk River. You're too late. It's a system of prior appropriation. They have the senior water right. There's no more water to be appropriated. You can imagine that didn't sit well with the Native Americans at the time. They filed suit in a monumental decision. What we now know we call the Winters Doctrine. They took it to the Supreme Court. The Supreme Court found that by virtue of the fact that the Indian reservation, the Fort Belknap Indian Reservation, had been taken out of the public domain, that Congress had, and they were given a specific task of becoming kind of an agrarian people, that Congress had an implied water right by that reservation. And that water right had a priority date equal to the equal to the reservation date of the reservation. Which is great. It helped them. So the Supreme Court said, hey, you got a water right. It's equal to your reservation date. Good thing, right? Now the Native Americans, the Fort Belknap Indian Reservation, get their water from the Milk River, and they have a senior right over the other white settlers who had settled subsequent to that reservation. Well, there were some other implications as a result of this, because you can think of other types of federal reservations. It's not just Indian reservations, which, by the way, Utah obviously has a lot of them, and a big one in the Southeastern Colorado River drainage. The problem with having these Federal Reserve rights is they're unquantified. And the general adjudication, the whole point of doing adjudication is to quantify things, but you can't sue the federal government unless the federal government lets you sue them. And you can see that they probably have no incentive to allow people to sue them. So it was really a challenge to do any type of adjudicating on the federal government, because they can say, federal sovereign immunity, tough. We don't have to respond to you, little puny little state engineer guy. We're the federal government, we can do what we want, and we'll go ahead and divert whatever water we want. Well, in 1952, there was a senator by the name of McCarran from Nevada, and he said, well, that's not fair. Here you are having these states trying to figure out what their water rights are, trying to balance their budget. And so him and actually, I believe, a senator or a representative from Utah co-sponsored a bill, and I don't remember this. It's named McCarran. Obviously, he was the main guy. In any case, he ran a piece of legislation through the U.S. Congress and passed a law that said, hey, in terms of water rights adjudications, the federal government automatically waives its federal sovereign immunity, meaning they have to comply with the state law at that level. They have to file their claims, they have to participate, and they have to quantify those rights, okay? And so you can imagine that's really beneficial to the state if we can say, hey, federal government, here's your summons, you have 90 days to file your claims. Now suddenly they've got to quantify what those Federal Reserve rights are, which haven't heretofore been quantified. Now, many of us probably in the room here are familiar with the Navajo reservation that's in this corner of the state. So the general adjudication is kind of like the sword of Damocles that hangs over top the federal government saying, hey, either work with the state of Utah to figure out what these water rights are and negotiate them. Otherwise, we're going to come in and we're going to force you and we're going to litigate it out. Now, the state of Utah has taken a different approach, and we've simply said we would prefer to negotiate with the federal government because we've learned from Wyoming and we've learned from Idaho, and we've learned from Oregon that litigating Federal Reserve rights is expensive and can be costly to the state, okay? Both in money, but also in water. And so the state, and you've probably seen it in the news, I believe Senator Romney just introduced a bill to memorialize the settlement negotiation with the Navajos. And that's that will be wrapped up into this general adjudication. So in this part of the state, actually in the southeastern Colorado River drainage, we haven't joined the United States yet because we're waiting on that settlement to get done before we spook them by saying, all right, here's your summons, you have 90 days. So in this case, southeastern Colorado, we will essentially join them at some point in the future, and they'll have to file claims. We're really close to getting this settlement negotiations done, and that's why we haven't joined them yet. But most other places in the state, we have joined them, and they have filed claims. It's just we're kind of trying to be careful not to really ruin a good thing. Because I think we've negotiated a good settlement, and the state engineer and the governor are very committed to ensuring that we're good on that commitment. But anyways, this is the one instance I know where you can sue the federal government in state court, and they have to comply with state law to do these types of things. It's pretty neat. All right, another reason why we do conduct general adjudications to prevent multiplicity of suits. We just don't want people going around suing everyone. We just want to wrap it up into one big, gigantic lawsuit and get it done, pull off that Band-Aid quick and move on. Okay, here's the most controversial thing that you're probably going to hear tonight, all right? So throughout the West, you know, the most ideal concept would be if you need water, you get water, right? If the demand equaled the supply, how awesome that would be. But we live in the West, the demand for water is always going to exceed the supply of water. So what you'll find in most Western states is this concept of use it or lose it. And that was really to ensure that people could acquire a right if they had a beneficial use. If they appropriated a water right and they put it to beneficial use, they're great. But if they're simply acquiring rights for purposes of monopolizing it, saying, oh, now you got to come to me if you want water, the state founders were really concerned about that. And so they've written into law that, hey, if you fail to use your water right for a period of 7 years or more, it could be subject to forfeiture, okay? This is where everyone's, kind of gets their attention a little bit. So in the general adjudication, that's one thing we look for, is if a water right has not been used for a period of 7 years or more, we could recommend to the court that it no longer exists. Again, that bothers a lot of people, but if you look at it from the flip side, let's say you're a new development, have a new water right, and let's say another gentleman has an older water right, and let's say it's an 1847 priority date on it, and he just hasn't used it forever. Well, developments and communities have developed on the water that he's failing to use, right? And if he suddenly came back in and said, oh, it's 2019, I want my water based on this priority right, this priority date, suddenly he's yanked water from underneath these communities that have grown up relying on that source of water. So that's another reason why this statute exists, because there's not enough water to satisfy everyone's demands. It's to ensure that people who want water are using it and it's being put to beneficial use. You guys are a real good crowd. You haven't asked one question. Usually by this time, I have millions of questions. But what happens is one person asks a question, then the floodgates kind of open up, and then we get bogged down. But usually this slide takes a lot longer. The last thing we want to do when we conduct general adjudications is to get a final decree. We just want all the rights decreed in one. And so you might have a perfected water right, but getting a decreed water right is a legitimate water right, whereas your certificate is prima facie evidence of the water right. A decreed water right is just that much better. So at the end of this, if you have a water right, even if you filed proof on it, and you file a claim, we come out, we put in the proposed determination, it gets decreed, now suddenly you have a decreed water right. It's all that more better. Okay, so the adjudication process. Yes, ma'am.
I have a bunch of questions. So why is this being done now? Is it being done throughout the state?
Let me start. Let's just take them one at a time, okay? So why is this being done now? Well, as you know, as I said, this kind of started in the 50s, but why is it being done here in Moab now? Why are we finally doing a subdivision? I mean, we've done subdivisions in Castle Valley in the 2000s and stuff, but really I think what's prompted this, and Mark can probably speak to this a little bit better than the regional engineer, is I know that there's increased interest in how much water is really being used in the Spanish Valley. Right? There's a new geological report coming out saying this is how much wet water we have in the valley. And the adjudication is one way to kind of get rid of all the rights that have not been used to understand, all right, we have this much wet water, how much paper water do we have? So Mark thought it might be a good idea, hey, we're going to eventually have to do adjudication. This is a critical time right now when we're exploring future policies for the Spanish Valley. Let's do this just so we have a better understanding of what liabilities we have against our wet water. When I say liabilities, what demands we have on it. So there is some instance everywhere else, like I get that question in Salt Lake Valley, and my answer to them is it's just your time, because we've been marching around the valley for almost 80 years now, and it's just finally your time. Here, it was actually prompted by the regional engineer just to kind of get a better handle on what type of water rights we have in the valley and if any have been abandoned. Okay, what was your next question?
So you answered one. The other one would have been, is it being done throughout the state? Now I know it's just being done here.
No, it's being done. So let me go back to this map, if you don't mind. So it is being done throughout the state. Now, I have a team of like 12 people, okay? Most of my efforts are actually focused in the Salt Lake Valley, right here. This is the Utah Lake Jordan River General Adjudication, been going on since 1936, okay? So I have 90% of my efforts focused here. I have some efforts going on here, some up in Bear River, some in the Virgin River. So it's not all over the state, but there's efforts throughout the state. This happens to be one of those efforts. What was your next question?
So what is being done with forfeited rights?
What is being done with forfeited rights? And I'm repeating your question for the benefits of the online users and for everybody else. So what happens is they just get put away in a file, and they don't get acquired, they just become dead. They become void, null and void, okay?
So no one who's developing wants to build a 10-story building, take that water
Yeah, that's a good question. I get a lot. So his question is, so is there some kind of incentive to do this where you forfeit these rights, then this division of water rights kind of hoards these and kind of hands them over to their buddy, Monsanto or Walmart or some nefarious actor, and then they build a big development? And the answer is no. They just go away. They just become no longer effective. Okay, so in this case, this gentleman has a well, shares it with 5 other people. There's probably a water right associated with that well. It's unclear to me whether there are 5 water rights or it's 1 water right. Yeah, we'll go both scenarios, right? First, scenario number 1, there's 1 water right. 5 people have interest in this 1 water right from this well, okay? And the question is, what if 3 people don't file a claim or choose not to participate? Potentially, if it's 1 water right and you file a claim on the water right, we're going to come out and we're going to evaluate it. And even if those people don't participate, we're just going to say, oh, there's 5 people connected to this well. They're all using it. We're going to carry on, all right? We're going to recognize the water right and drive on. Now let's talk about the scenario where there are 5 water rights and 1 well. That means the requirement, every owner has to file a claim for their individual water right. So, and what I'm going to talk about here a little bit is, if you fail to file a claim as part of this, that water right gets judged abandoned. So there will only be 2 water rights left. If you're one of those people that filed a claim, it doesn't really have an impact on you. You still have your water right. You can still use that well to whatever extent you were using it before. But those people who failed to file a claim, their water right may become abandoned. Now they'll get notice of it and they'll have an opportunity to object and file a claim. Honestly, we're not looking for people not to file claims. We want them to file claims. So we try to make it like almost, proof, I say private proof or idiot proof to avoid screwing this up down the road. Did that answer your question? Yes, sir.
How does groundwater storage and or groundwater quality correlate with the adjudication process?
So his question is, how does groundwater storage or groundwater quality correlate with the adjudication process? And quite frankly, I'm going to say there's probably not much correlation at all. All we're looking at is the basis of the water rights. So if you have a groundwater right, a well water right, all we're looking for is the beneficial use associated with that to recognize the water right. The Department of Environmental Quality, Department of Drinking Water, the Department of Environmental Quality, and then the Division of Drinking Water, Division of Water Quality, they might have something more to say about the quality of the water, the underground water. That's not really our lane. All right? Back in the back. So his question is a certificate of beneficial use and a water right the same thing? A certificate of beneficial use represents that you have perfected a water right. So a certificate is part of a water right. It's part of the process. When you appropriate a water right, you file an application, you develop the works, you put it to beneficial use, you file proof on that application, and then the state engineer issues a certificate saying you have proved up on your water right or you have perfected your water right. So when we talk about certificate of beneficial use, that's what we're talking about, is that, hey, you have a certificated water right or a perfected water right. Okay? Yes, sir.
My question has to do with current events. In Spanish Valley, there is a lot of water development, sewer development, for anticipated growth in San Juan County. Is there water now for those additional households that are planned, at least within this plan, as you build in Spanish Valley? And the reason I'm asking is I'd like to know if there are competitive requests for water to be adjudicated by the states to those as to for unbuilt houses and those unbuilt communities.
Okay, I'm going to try to do my best to summarize your question in a lot shorter statement. Okay, this question is, there's a lot of development going on, especially in San Juan County. Is there water to be had for those development? Even, is there future unappropriated water? He used the term adjudicated. And I think that's part of the terminology we need to clarify, is adjudication and appropriation are two separate systems. So what you're talking about is there water to be appropriated in the future. That is something that the regional engineer is pursuing studies to determine. There have been applications that have been approved. They're coming to a conclusion on how much wet water there currently is. They know that there are existing perfected applications out there for a certain amount of water. There's so much paper water already out there. They're trying to determine how much real wet water there is and whether the delta between those two, the difference between those two, if there's additional water to be appropriated in the groundwater. There's always water in the Colorado River, right? And the state owns portion of that from the Colorado River Compact of 1922. But really, you're talking about an appropriation issue and maybe not so much an adjudication issue. I would encourage you to ask Mark Stilson about any future appropriations policies, because that's not really my lane. I don't know I can speak very intelligently about it. Yeah, if you want to stay after, Mark, we'll answer your question, talk to y'all about it. Yes, sir.
If you've already proved up on your well, are you going to have to redo that?
So that's a great question. His question is, if I've already proved up on my well, am I going to have to redo that doggone blasted process again? The answer is yes and no. No, you're not going to have to file proof. You will have to file a claim. But if you have a water right on a record, we're going to send you the claim already filled out. It's as easy as signing your name and mailing it back, okay? It doesn't require you to hire an engineer or a surveyor to file proof or anything like that. It's a lot less invasive process. And then members of Mark's staff will contact you for an opportunity to come out and inspect your claim. Just say, yep, you got a well, looks good to go. So it should be relatively painless. Of course, you can never trust a government entity that says anything's going to be painless, and I understand it. And we all got better things to do than deal with a bureaucracy at the state level. Totally understand. But we've tried to make it easy, and we have staff here try to facilitate that process to the greatest extent possible. Yes, ma'am?
What's the timeline going to be on?
I have a timeline slide in this. Okay, so I'll get to that, and I think it'll answer your question. I'm going to take 2 more questions, and I'm going to move on to the next slide just so those who want to get out of here can go. Yes, sir?
What determined the adjudication boundary?
Oh, okay, that's a great question.
We got letters that are outside.
Yeah, I'm going to talk about that. That's good.
Let me continue. There's also wells that are outside the adjudication boundary that are going into Spanish Valley, owned by Spanish Valley District, and why weren't those included in the adjudication process?
Yeah, it's a good question. So his question is, what really determined the adjudication boundary? And also, I live in Blanding. Why did I receive a notice for this? Okay, so two answers to that. First of all, what defines the boundary? The boundary is essentially me trying to say, all right, we have this many property owners and this many water rights. I need to carve this up as hydrologically feasible as I possibly can, but at some point I have to just draw a line. I try to follow hydrologic features to ensure that water that's draining into the same source are captured in the same subdivision. So what determines the line? I determine the line, with the exception of the overall adjudication, Southeastern Colorado River. So the subdivision line was just my best guess to say, I can only do this many claims in a prompt amount of time, and I have to notify all these property owners, so I'm going to make it this size. Some areas it's a lot bigger, some it's a lot less smaller. Let's go to your second part of the question. Why did I receive notice if I don't have any property inside that subdivision boundary? That was a little bit of a flub on my part. What happened is I'm in contact with San Juan County Recorder. I said, hey, can you give me the tax records and mailing addresses for everyone in San Juan County? And then I get a GIS shape file, for those of you who know, so essentially a file that has all the parcel information. And I try to do a filter to say, I only am interested in these parcels in this area, and I have to run it through a spreadsheet and all this technical stuff. And when I did my initial filter, it just it did a little bug on me because San Juan County has some funky numbers associated with its parcels. And when you do a certain function in Excel, it just didn't work out great. So I sent it to 300 more people than I should have sent it to. So that, if you're here and you live in Blanding or somewhere else, I apologize. We sent out 2,000 notices. There's probably about 370 of those that probably shouldn't have been sent at the end of the day. And then the next question I think you had is, there are wells that are tributary, or there's sources of water that are tributary to the Spanish Valley. What about those? And my answer is, well, those will get caught eventually down the road as we continue to adjudicate different subdivisions. We can only do kind of one bite at a time. We started the Moab North Subdivision this time last year. We're doing Moab South, and we'll work with the regional office to determine, because it's really their staff who are doing this, what the next step is. All right, and the last question on this slide, and then yes, sir. Oh, is there any cost with the paperwork? Is that what you're asking? No, there's no. So his question is there any cost associated with filing a claim or anything like that? Absolutely not. It will send you the claim. I guess it's a cost of a stamp, but you can even email it to us, so it's cost of the electrons going down your email, I guess. But no, there's no fee associated with filing a claim. It's a civil procedure. Back in the day, they actually did charge a fee to file a claim, and that's how they funded the adjudication. That was found kind of unconstitutional. You're charging people a fee to defend their property right. Yeah, obviously not a very good idea. So let's get through this slide, and then we'll do another round of questions, okay? So here's the adjudication process. Right now, we are in step number 4, the public meeting. We've sent out the summons. We've published notice in the newspaper. The petition happened a long time ago, back in the 50s. The next step, and I'm going to dive into these next steps, a lot more detail in the next couple of slides. We're going to send out notice to file claims. So if you receive notice of this tonight, unless you're one of those 377 that received the summons on accident, you'll receive a notice here in a few weeks to file claims, and it will give you instructions. And again, I'm going to dive into that, so hold your questions. People who have a water right on our records, so if you have appropriated a water right and it's on our records and you fail to file a claim, your water right would end up on this list of unclaimed rights. We would send notice of that to you. You have 90 days to file an objection. We hold another public meeting. So if you see your name or you see your water right on this list of unclaimed rights, you'll want to file an objection, trust me. Again, I'll get in more detail. We do a final summons just to make sure we didn't miss anybody. We publish it in the newspaper for 5 weeks. And then we have to get all the objections resolved before we can get a decree on the list of unclaimed rights. So that list is just anyone who failed to file a claim. And the judge enters a decree saying, hey, by virtue of the fact that they have failed to participate, those water rights are just going to be considered abandoned. Okay? For those who did file a claim, we'll send out our team to contact you, evaluate your claim to make sure that, hey, the well is there, they are using this type of beneficial use. And then we'll take our evaluation, we'll put it in what we call the proposed determination, which is kind of the state engineer's official recommendation to the court, saying, this is what we think this water right should look like. People have 90 days to file an objection. If they don't like how the state engineer has made a recommendation on their claim, we'll hold another public meeting like this. Only those who filed a claim will get notice of the proposed determination and this next public meeting. Sometimes we have 0 people actually attend that public meeting, but we're statutorily obligated to file it. It gives me an excuse to come down to Moab. Hey, I'm not going to argue. And then we have to resolve any objections that are associated with the proposed determination. So if you didn't like what the state engineer put in his recommendation to the court, you file an objection, and then the law is that we've got to figure out either we've got to litigate or we've got to come to an agreement on what that is. If it's an honest mistake, hey, we will acquiesce easily. Like, yep, we screwed up, we will fix it. But if it's something that we just don't agree with, we may choose to litigate that, all right? So if you say, I'm irrigating 100 acres, we get out and we can only find 50 acres, and that's what goes in our recommendation, and you say, I disagree, I object, I'm irrigating 100 acres, we would say, all right, I guess we're going to have to litigate, get your attorney involved, and then we'll see you in court. At the end of that, hopefully we get a decree out of that. So let's dive into the details. The next step is going to be filing your water user's claim. So we will send notice to those of you who received this notice, again, except for those 377 who should have never received notice in the first place. In the next couple of weeks, you'll receive notice to file a claim. In that notice will either be A blank water user's claim, that means you're a property owner and we don't know if you own a water right or not, but we're just covering our bases. Here's a blank water user's claim. And if you have a well, maybe it's one of these wells that was drilled prior to 1935 and you haven't established a record on the state engineer's record yet. Or maybe it's a surface water right prior to 1903. This would be your opportunity to claim that, okay? For those who are water right owners of record, we will send the claim out, but it will already be filled out with what we have on our records. If you receive and you can scratch stuff out, you can modify it however you want. It's only for your convenience. It's your claim, okay? And this claim acts as your pleading in the court. Then you have 90 days from the day that notice is mailed to return that claim either to the state engineer's office or you can file it with the court. The courthouse is here in Moab. It's pretty straightforward. If you don't want to, you want to save some postage and just file it with the clerk of the court, go for it. They might kind of look at you funny because this is kind of a weird process for them. I think they're getting more comfortable with it since we just did the Moab North one. The easiest thing is just to send it back to the state engineer's office and we'll process it. But again, you'll have 90 days to do that. If you think you need more time than that, you can request a 30-day extension. That email address or these email addresses I'll have at the end of the presentation, you can just say, I want to have a 30-day extension. But you have to get that to us prior to the expiration of that original 90 days. So you can have another 30 days, you just got to request it prior to the expiration of that first 90 days. And then we'll come out and we'll look at your claim. Hopefully you've put some contact information, hopefully an email address or a phone number where we can get a hold of you prior to going to your house or your property so you can show us your claim, right? That's a lot easier than trying to be, skulk around in someone's backyard and hope to not get shot or get bitten by a dog. We want you there. We want you to explain, especially if it's a complex system that how you figured out how to irrigate or use your water, okay? And then we will evaluate that and make our recommendation in the proposed determination. But first, let's talk list of unclaimed rights. You remember back in the Mark's office and in our office in Salt Lake City, we have this big file room that just has nothing but file jackets of water rights. Those are what we're calling water rights of record, meaning we have a record of your water right. If someone doesn't claim one of those water rights and those water rights happen to exist in this subdivision boundary, that water right gets published on this list of unclaimed rights. We'll send the notice to the same people who received the notice tonight. We'll hold a public meeting. People have 90 days. So let's say you own a water right of record, and for some reason you got caught up, you forgot, you failed to file a claim. There's some reason that excuses your failure to file a claim. You can file an objection with the court. It has to go to the court. And file a claim at that time and then file a claim with the state engineers. And we can either choose to litigate that objection or not, but usually what happens is that's fine. As long as you provide a reasonable excuse as to why you failed to file a claim, again, we're not interested in people abandoning their rights that they intend to keep. So we usually don't fight those. Usually what happens is we just enter a motion to the court saying, please accept the claim and remove that water right from the list of unclaimed rights. And it's pretty straightforward, okay? And then at the conclusion of that, we get a judicial decree on the list of unclaimed rights, and any right that's remaining on that gets decreed abandoned. This also is the threshold for claiming a pre-statutory right. Up until this judicial decree, people could claim a diligence claim. They could claim that, my great-great-grandfather has been irrigating using this creek prior to 1903, and they could file what's called a diligence claim, saying, hey, we've been using this pre-statutorily. Well, once this decree gets entered, you can no longer file those claims. In essence, your ability to assert those pre-statutory claims for either groundwater or surface rights is barred from there moving forward. That's the whole purpose, right? We want to bring those pre-statutory rights onto the record. This is kind of the mechanism, one of the original mechanisms for getting that done. Yes, sir.
So, what are the criteria for beneficial use in terms of number of acre feet?
So the question is, what are the criteria for beneficial use? So it's really the use, right? So if you have an irrigation right, we're going to look to see how many acres of irrigation you have. You have to show that, yeah, I'm irrigating this acres. Now you might ask, well, does it have to be a certain type of field? How robust of a crop does it have to be? Trust us, we're not here to judge your farming abilities. As long as you're putting water down and trying to irrigate something, again, we're here to help you prepare, keep your water right. We're not looking to take anyone's water right. So, or it's going to be the number of stock you have that are drinking, or it's going to be your house connected to the well for culinary purposes. Those are the types of things. Those are our standards for beneficial use. Did that answer your question?
Yes.
Okay. Yes, sir.
Since if I understand you right, there's a difference between water right and water share. Should that water share be listed on the previous slide where you get the blank form?
That's a great question. So his question is, there's a difference between, he understands there's a difference between water rights and water shares. Do those water shares, do they get a claim, or are we going to send claims out to those shareholders? The answer is probably not, definitely not. We will send a claim to the irrigation company for their water right. Now, do shareholders just tune out and not listen anymore? No, I'd encourage you to be actively making sure that the board of that company is participating, because if they fail to file a claim, the same rules apply. Their water right gets abandoned. And so if you're a shareholder, like I'm a shareholder in an irrigation company in northern Utah, I would be making sure I'd be calling up Lewis Johnson and saying, hey, you get your claim filed for us yet? And if they just are kind of not doing it, you can always file a claim for the irrigation company. I mean, we'll say that's good enough. It gets your foot in the door. We're not going to put it on the list of unclaimed rights. And we've had that happen as well. So if your irrigation companies like mine kind of ran out of a glove box of an old Chevy truck and you just don't have their stuff together, you don't have money for attorneys to figure this stuff out, but you're competent and you know how to file a claim, go ahead and file a claim and we'll make sure it doesn't end up on the list of unclaimed rights. Okay? Good? Driving on? Yes, sir.
What if you live inside the map and you did get a summons in the mail?
So if you live inside the map but you didn't get a summons in the mail, and you have a well, boy, that's the trifecta of concern, isn't it? Let's get your name on the list, and the best way to do that is to send me an email with your mailing information. The only thing I can think of is the county records are incomplete. You're not the owner of record for your water right. Maybe you acquired this property recently and haven't updated title with us, so we sent the notice to the old owner of the water right, and it may have gotten bounced back to us. I'm not sure, but to ensure you receive notice moving forward, send me your contact information and I'll add you to the mailing list. All right? And we can take a look at it a little bit later and see what's going on, but I don't have the spreadsheet in front of me. And I'll say right now, San Juan or Grand County records, they're not the most complete set of records. I'm just going to say that right now, is that there are big holes of area that I could not identify a property owner with. So, but it's concerning if you live in town, because usually those are pretty well defined. So let me know. All right, should we drive on? Yes, ma'am.
This is a similar question. We didn't receive the summons either.
Okay.
And we're here because everybody else has. And when I checked, apparently it's in the name of somebody who's been dead.
So your water right is in the name of an old dead person.
But it's on our deed.
Okay, it's a great question. So her question is, I didn't receive notice. I'm here because everyone said, hey, we're going, heads up. You received notice through the owner of the water right is a deceased person. So the fact of the matter is you probably are the owner of the water right, but our office doesn't, the records, are you in San Juan County or Grand County? San Juan County. So the county doesn't say, hey, Division of Water Rights, this person's moved out, you need to update this water right for this well. Our records and the county records don't correlate. So what is really required is, you may have acquired the parcel and the property and the water right, but our records are still down here at the original dude's name. And so what's required is you need to update title. And I'll talk a little bit about, those are some of the issues. Update title with our office by filing what's called a report of conveyance to ensure that that water right's in your name. But in the meantime, email me with your mailing information and I'll get you added to the list.
Can I talk to you at the end of the hour?
Sorry?
Can I just talk with you at the end of the hour?
Absolutely. You can talk my ear off. All right, let's keep on driving on. So after the list of unclaimed rights gets decreed, we're going to then take all of our evaluations and put it in a proposed determination. We're going to send out notice to those who have actively participated, either by filing a claim or saying, I want to participate, and we hold a public meeting. You have 90 days to file an objection if you don't like how the state engineers evaluated your water right. We are required again to resolve those objections. We either litigate, negotiate, or seek a voluntary withdrawal of the objection. But again, that's your opportunity to say, I don't like how the state engineers evaluated my water right. Judge, you need to adjudicate our disagreement between each other. And then once we get all those objections resolved, we ask the court to issue a judicial decree on the water rights, on the proposed determination. And then they all have decreed rights. Here's the map. All those green dots represent points of diversion. I have bigger scaled maps out here on the table that actually have the water right numbers associated with all those points. So if you know where you live, you can go look at that and say, hey, that dot's on my property. Hey, and that number associated with that dot, that's your water right number probably, okay? So that's out for your own edification. We sent out, there's approximately 468 water rights of record in this area. Again, those are the actual water rights we have in our office. Most of them are underground wells. We sent out notice to 2,100 plus people. Again, 370 some odd of those were probably erroneously sent. Here's the issues and anticipated timeline. We already kind of talked about the out-of-date title. Again, our office doesn't track with the county recorder's office. So if you've recently acquired a property or if you've acquired a property that had a well on it, very well, the deed probably most likely conveyed that water right to you, all right? But our records don't reflect that. So any notices we send out to the person who originally appropriated the water right with our office. And so it's incumbent on the new owner to update our records so that we can get notifications to them. You don't have to do that to participate in the adjudication. We will still come out and evaluate your claim. You can still file a claim even though it's not in your name. We'll still come out and we'll look at it. We just encourage people to do it because if you ever tried to renovate the well or anything like that, you wouldn't be able to unless you were the owner of record on our records because we won't allow people to renovate other people's wells, and so we want to make sure you are actually the owner of the well. And you do that through a title process called a report of conveyance. We also have these no proof required water rights. What happened was during World War II, there weren't a whole lot of engineers or surveyors to help file proof on these water rights. So the Utah State Legislature said, hey, what we're going to do, if you have a small amount of water, we're just going to allow people to appropriate water and not require proof on those water rights. And that's great. The challenge has been, it was without a surveyor or an engineer coming in and filing proof, the location of where they say their well is really often inaccurate. And so you might look at some of these dots on this map or look on our web interface and you might say, that's not where my well is. It shows it's on the doghouse and it's on the other corner of the corner of the yard. You got to take those locations with a grain of salt. First of all, there's a variety of issues having to do with public land survey system interface with GIS systems, as well as this no proof required. So there's a whole host of issues. What you need to do is look in the general vicinity of your property and say, where is that green dot? That's probably the well I'm talking about. And we have staff on hand that can help you navigate and help you understand whether truly that is in fact the water right associated with the well in your backyard. Okay, anticipated timeline to answer this young lady's question. In May, next couple of weeks, we're going to send out notice to file claims. Again, you'll receive that in the mail with either a blank claim or a claim that's filled out. You'll have 90 days to file the claim. In July, that 90-day claim filing period concludes. We'll be investigating filed water users' claims. We'll probably start investigating them as they come in. We're not going to wait until July to do that. But in November, we anticipate publishing the list of unclaimed rights. We'll hold a public meeting, and that 90-day objection period to the list of unclaimed rights will begin. In February of 2020, that 90-day objection period will conclude for the list of unclaimed rights. And then it'll take us some time to actually digest these water rights, do the evaluation, and make a recommendation. We hope to publish that in August of 2020. And then, again, that 90-day objection period will start at that time and then conclude in November. So this is an anticipated timeline. Depending on how many claims get filed, depending on how many objections to the list of unclaimed rights there are and how litigious those issues are, there's some kind of fluff built into this schedule, but this is pretty close. All right, well, I lose my water right. Probably the question on everyone's mind. Water users who are currently using their water rights in conformance with the records of the state engineer don't really have anything to worry about as long as they file their claim, all right? You don't want to risk having your claim abandoned just because you failed to mail in a piece of paper. Individuals using water without a water right of record are required to file a claim. Again, so if you are using water in a well that was drilled prior to 1935 and you've never needed a water right before, you're required to file a claim. Otherwise, you're cut off. Okay? Same thing for surface rights prior to 1903. If the water use authorized under the water right is fallen out of use for 7 years or more, the water right or a portion of it could be recommended to be disallowed in the proposed determination. So if you have a water right for 100 acres and you've only been irrigating 50 acres for the last 7 years, our recommendation is going to say your water right is now 50 acres, meaning you've forfeited the other 50 acres of that water right. So we're going to trim the water right. So if you take any message away, when we come out to evaluate your water right, show that you're using it all, right? Like, get all your irrigation out. Let's make sure that and you haven't been putting it to beneficial use, put it to beneficial use. We're not going to play CSI water rights and try to, unless it's just blatantly obvious that you haven't been using it, but just put it to beneficial use. We'll come out, we'll investigate the claim, and if we see your water rights being used, there's not a whole lot of need to explore any further. We're just going to march on, right? The objective is compliance, right? We want people to use their water. Yes, ma'am.
So, say there is an abandoned well, you're going to take the water rights away and stuff, but is it up to you guys to come out and abandon that well?
So your question is, there's an abandoned well and the water rights are going to go away. It's up to us to come out and abandon it. So I think we need to clarify what I mean when I say abandon versus I think the classical sense of abandoning a well, which is kind of plugging. Yeah, we're abandoned, the water right's been abandoned. The actual abandonment of the well is actually the obligation of the property owner to plug and cap that well if they have a well that they're no longer using anymore. Obviously, we don't want things falling down there. We don't want to introduce contaminants into the groundwater. So it's really, the requirement is on the water user itself, the owner of the well, to cap and abandon it. Okay. Who can I contact? That's me at the top. That's Mark. Second, Dave is assistant regional engineer. And then Rick Wild is one of those water rights specialists. And they have a whole host of interns that are actually out here working in the field. If you have any questions, I'm always happy to answer them. I'm going to check my email, see if anyone online has drafted a question. Here we are. I got a couple of them. Okay, so this is a question. It says from Charles McDardle, when will the presentation of the Utah Water Rights Adjudication be posted online? The online presentation keeps going offline for 5 and 10 minutes at a time. I'm sorry, Charles. This will be posted on YouTube tomorrow morning. The actual slide deck will be posted on our website probably Monday. So you'll be able to go back and flip through these slides. This presentation is very similar to the last 30 presentations I've done. If you go onto our YouTube channel, you'll see a lot of these. And so there's only like two slides that are different, actually. There's probably only one slide that's different. Well, two, I guess, the timeline and the map. But a lot of the information is the same, okay? All right, there's another question on here. Sorry, I only got to watch about 15 minutes of the presentation. Kept going offline. You have a question, however. I was told when all of this started that there would be no problem with the residents keeping their water rights and wells. This adjudication comes as a surprise to us. We have certificates of beneficial use and are allotted 1.95 acre feet of water with them. There are 4 households on San Juan well number 3. My personal water right number is such and such. Do I still have to support my claim? And if so, what do I need to secure my rights? And then he gives his name and email address. The answer is you need to file a water user's claim. And again, this individual has a water right of record, it appears. He'll be mailed a claim that's already filled out. He simply needs to sign. If he wants to make corrections to it, he can make corrections for whatever it's worth and mail it back. It's pretty straightforward, and then we'll come out and we'll evaluate it, okay? And I'm going to respond to this person in email later just to answer more of his specific questions. So, I think that's all the email questions. Are there any other questions from the audience? Yes, sir. What if you don't want to hook up to city water? Then don't do it. Power to you, brother. I don't know. I honestly have nothing to say about that. I have no opinion on the matter. If you have your own water well and you're using it, good. Keep on doing so. Any other questions? I did. Okay, I'm going to stand by, and Mark, I'm sure we'll be here for a little bit. Feel free to wander on up. And sorry, there's one more thing I did want to show, and that was our online interface that you may want to use if you. Let me just turn on my Wi-Fi hotspot here. This is a real helpful interface that you can use to kind of drill down into your property and see where. So you don't have to refer to these maps. You can just go on our online interface and look at the aerial imagery. Okay. So let me bring it up here. See, hopefully it's working now. And I just go to water rights. Okay, so this is our home page. All right. The easiest way to get to our map interface. So there's two different things I want to show you. First, I'm going to show you our adjudication interface, and then I'll show you the map interface. If you come down here to these little scales. These things that look like a balance. And you click that. It'll bring you up to here, right? And this is kind of that link on your summons notice had this. If you go to this button that says Active Adjudications and click it, you'll see right near the top Moab South 055. And it will bring up, if you want to bring up a map of the entire adjudication area, it'll bring up the area, and it will show all the points of division. So all these green dots are going to be reflected on this interface. We'll see how fast this does it. I'm a little concerned because I'm using my phone, so it may not be super fast, but let's see what happens. But it's a pretty slick interface. I'm going to, let's see what happens. Oh, man, we got a water right clear. It was obviously in the wrong township and range, Mark. We need to look at that. All right, let's zoom in since it's not doing a good job of zooming in for us into Moab area. Yeah, I'm not sure. I think I've seen that one before. We just need to look at correcting that. There's Green River. I'm getting closer. Here we are. Okay, so now it's going to slow down. There we are. So this is the Moab North area. That's the subdivision we started last year. The Moab South is this area. And so this will show you all the water rights that we're tracking as water rights of records on our database. Part of which, you'll notice that some are red and some are blue. The red icons represent wells. The blue icons represent surface diversions, okay? So I'm going to go ahead and kind of zoom in here a little bit just so you can get a better idea. Here's a lone couple of wells. So let's say you're this property owner here, right? You can click on that well and it'll kind of give you a summary of the details. But if you select the hyperlink here at the top, right there, it will take you to our database. And this will show you all the information that we have on this water right. So when you get a water user's claim, this is the information that will be reflected on this. And you can even go to the scanned documents and see what documents we have on our records for this particular water right. Okay? Now, if you're not good at map interfaces, you're not sure how to, conceptualize where you are on this aerial imagery, you can also do a little search. You can go up to this tab up here. It's already defaulted there. And you can say, I want to search by my address, okay? Someone want to give me an address? Anyone? 4670 Sunny Acres? Oh, I spelled that wrong. Delete. Fortunately, this is a pretty forgiving program, and even if it's not in Moab, it will still bring it up. I'm going to take. It says no address found. 4607. Okay, I apologize. I heard that wrong. Yeah, no address found. Anyways, you might be on your own, just scrolling around there. Sorry, is there a better address for a more established house?
5048 Spanish Valley Drive.
All right, let's try that. 50. That's the first time this thing's ever let me down. 5048 Spanish Valley Drive. All right, no address found. I have no idea what's going on. I mean, that's it, right? Yeah, I mean, you can try that. Oh, there it goes. Let's get rid of this and zoom into it. So maybe that was the issue. Maybe it didn't like the fact that I had Moab. Does that look like your house? 5048 Spanish Valley Drive. Oh, that's Monticello. Oh, yeah, it's probably not your house, I'm guessing. I'm not sure. So looks like it's not quite as robust search system here as it is maybe in the Salt Lake Valley. I apologize. So I'll give it a shot. If it doesn't work, then you can simply go there. All right. That's the easiest way. One last thing to show you is if you want to know the status of your water right, you can go to that hyperlink, the 055, and it will bring up a list of all the water rights that we're looking at, and it will kind of give you an idea of what the status is. So this progress box down here would match one of these colors. So right now, we've simply served summons, so they're all white. Next, we'll send out notice to file claims that all turn orange. And then once you file the claim and we've received it, we'll update it to show it's been filed. And then it's kind of on us to field review it and issue a state engineer's recommendation. If you fail to file a claim, after that 90-day period, it will turn red. But this is another way you can kind of search for your name, or search for a water right, and then it also gives you an ability to look at where that water right falls on the map as you select it. So play around. There's some cool features. Bottom line is, if you're, so this is a water right that they've apparently filed proof on, and I can tell that because they've mapped the beneficial use, the area of beneficial use. So this is probably a recently certificated one to some degree. So. All right, that really concludes my presentation this time. Any other questions you have? All right, thank you for your time.